pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine for
My bitch a choosy lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm putting bitches off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
a pimp, not a simp. A pimp, not a simp.
Hello, everybody. Welcome to tonight's stream. We have another guest with us this evening. This is Grey. I kept on saying Grey777, but it's Grey777. Grey Night. And I believe it was last week. It was during my live stream of Accountability Angel when she was at a courthouse recording, and we were dressing down her actions there, and you told me in a stream that I was incorrect in my assessment on what somebody can or cannot do while in a courtroom. I gave you a couple of cases. You said that those were either not on point or spoke to different issues. And so I asked you if you wanted to come on to have a discussion about it. You agreed, and here we are. So thank you for stopping by. And I'll just give you this time to at least. I know we discussed this before going live that you don't have anything really necessarily to say, and I'm not asking you to give a life story, but really where your motivation is on deciding to call me out and tell me that I'm incorrect. So I'll give you the floor.
Yeah, well, thanks. I guess I should start by saying that I don't necessarily agree with her demeanor or the way that she presents herself. And I think in some of those videos, she was also going around possibly in defiance of mask laws. Like I came in towards the tail end of that stream. So if any of that was going on, I definitely have issues with all that, because I think that people do not have a constitutional right to walk around however they like and be in defiance of, whatever mandates are put out by the governor, not necessarily having the legislature pass them into law as a full body. And there's all those arguments, and there's a lot of auditors that kind of toe the line in other ways. I know there are auditors that go out there and bait people. I feel that, personally, she probably falls more into that category.
Mm-hmm.
Big energy on that one. But I think in general, there is a right to record public places. I probably didn't communicate myself exactly as precisely as I should. I think the language in the federal guidelines. I don't even think that it's like a law. It's just whatever. But it's basically foyers, hallways, entrances, lobbies, and auditoriums if they're used for public meetings. So those are really more the categories. I think I said just wherever the public is generally allowed to go, that's where you can film. And technically you could call me out and say you can't film in the ladies' room. So obviously, that doesn't count. I think that the one place where I would differ in your description of where we differed is that you said I objected that you can't record. Well, you can freely and without permission record in a courtroom, and I don't think that that's right. But I recognize that is restricted, and that is, you need the permission of a judge to do that. So I can't contest that. But I think that you had originally said, or I had originally said, courthouse. That's different. I think that in writ large, if you're in the lobby of a courthouse, if you're just walking around, if there's pictures on the wall, if there are people doing things, it might be newsworthy. And I think that people have a right to be able to record things there. I don't think they necessarily have a right to disseminate everything that they see there. If they catch somebody's personal information, for instance,
Mm-hmm.
there is a responsibility to someone who is going to communicate that as news to, redact that information to the best of their ability. And otherwise, they would be exposed to some, either criminal prosecution or some sort of tortious remedy. But like, yeah, that's it. Like, that's you should have the right to record in general, except for very tight strictures. I think you mentioned a few different cases that you thought were applicable, and I think that maybe we should go through those because yeah, we did. You mentioned that we did kind of differ on
Mm-hmm.
whether those apply. So like maybe we could go through them case by case.
Sure.
I got all of them, or like you mentioned some, and like then you said, well, this one doesn't really apply.
Hello.
Also have a am I still with you?
Oh, you were kind of cutting out just a second there. Go ahead.
No. Yeah, and I also have a few different videos that I think kind of support my argument that it's situations where I think you mentioned post office recording is like a kind of like an auditor thing, and it's a standard.
Right. Well,
I also differed on, but like, yeah, it's your show, so take us where you want to go.
Well, first we could go to post offices, but we can focus on what the originating issue, which was at a courthouse, which is what Accountability Angel was doing, and you had mentioned and you already said like in a courtroom during court proceedings, yes, a judge can have restrictions on recording, and that is absolutely correct. And the Supreme Court has already made that well established. Then the issue goes into the issue of the courthouse itself. I can't recall all of the cases that I did cite to you, but I do recall one that I did was United States versus Hastings, and that one, and I will note, and I think if I didn't mention it then, I'll mention it now. That one did specifically involve the courtroom and not the courthouse. However,
to go through, because I'm sorry to interrupt, but like if you do review this, I didn't take any notes on Hastings because like again, I have like, yeah, duh. Like I can't disagree with that one. Like that's the problem. Where I would differ with you is you have to be very precise in the test that they set for where that should be barred, because in general, like in practice, in the courts, like in my state, I live in Massachusetts.
mm-hmm.
Unless there's, if you appeal to the judge and you're like, hi, I'd like to record this, in an unobtrusive way, respectfully, and recording, just the bench, you're not really like, unless it's like some, high profile criminal case, or, it's like you said, family court, where like
Mm-hmm.
it might be very personal shit that's being discussed. A lot of it might not even be entirely truthful. There's a good reason to bar that from being broadcast. But like, if it's a criminal proceeding of somebody that like, just got busted for, some nonsense on the street, yeah, maybe that there should be some maybe that should be broadcast more frequently. And I think that that's something that we will probably see if it doesn't exist in law now. I mean, there's sunshine laws that have been proposed, at the highest levels of our government. In 2020, in the UK, they passed a law that says that now Crown courts shall be broadcast, and they said that that'll be enacted once COVID-19 is in the rear view.
Right.
So yeah, I think that's changing. A lot of those laws exist because of a time where photography was basically 100 people swarming around with little explosives inside of glass balls, and like, who the fuck wants that in your courtroom? So like, that was kind of where those original laws were, what was informing those laws. And even decades later, if you had video recording, you were coming in there with like a gang of dudes and like this giant robotical like recording thing holding a giant heavy camera and like a ton of lights to make everything visible.
Okay.
And, like, Yeah, I think that that's kind of what's informing the the prior decisions that are being carried over into now. And I think we're seeing that being reversed. But
Well, I don't know if I really agree with that in the because I would say yes in one sense I could agree that because in Chandler versus Florida, which is the Supreme Court ruling that there is no First Amendment right to record or televise your proceedings, that was 1981. So it's not as if the technology was so foregone that photography was as it was back in the 1940s.
broadcast cameras in 1981 were big, like bigger than you might realize.
Right. I'm also I'm talking about photography. You mentioned photography, and then you also mentioned video broadcasting. But to that end, the ruling Chandler versus Florida has been upheld in future cases, and even including modern cases. So it's the idea of restrictions in the courtroom are still there. The issue, the greater, and I think it's well established that in courtroom proceedings are really up to the judge. Let me put it this way: the discretion of the judge as far as allowing or disallowing recording during proceedings is pretty well founded, and I haven't seen that be reduced. I know you mentioned the law in Massachusetts where that's changing, but the discretion of the
let me clarify. It's the rules of procedure for the courts.
the court. Oh, okay. It's the courtroom procedure. Right. Gotcha. Okay. But at the same time, that's still something that's subject up to the court, right? It's up to their discretion on whether they're going to be more transparent and allow more broadcasting.
Yes, that's right.
So
it would take a legislative act at this point because it has been very, very clearly hammered out all the way to the top courts, and there's so much precedent behind it. Like, you can't just arbitrarily say "nuh-uh" and have a judge agree with you ever.
Right. So, in other cases, though, as we go along and move past the courtroom and into the courthouse, there are a number of cases that I found that support the idea that just as the court, the judges and the judiciary have wide latitude when it comes to to the courtrooms and proceedings, so too that they have that latitude in the courthouse itself. I have Combined Communications Corporation versus Fine Silver 672 F2D 818. It basically said no, there is no constitutional right to televise inside of a courthouse, and upheld the rule banning the use of audio and video equipment in the entirety.
I missed the beginning of that because I was responding to something that in the chat.
Sure, it's a Combined Communications Corporation versus Fine Silver 672 F2D 818. And in that case, it was explicitly talked about the issue of a courthouse. Now, a more recent case, let me see, I'm going to butcher this last name, Dorfman versus Meisner, 430 F2D 558. And this was a 1970 case. And what this case was about is that the court actually overturned a prohibition rule on audio video recording. But what they said was the issue that the facts of the case was that the courthouse or the courtroom shared building space with other non-government, non-judiciary entities. But the rule that was promulgated banned certain floors of the building. Those floors had courtrooms in there. But they also banned recording on the ground floor as well as the plaza and the sidewalks surrounding the courthouse. The court held that the restriction on the ground floor, the plaza, and the sidewalks was improper because there was no reasonable way that the usage of audio and video devices on those floors could disrupt the proceedings that didn't start until the 14th floor, right? The courthouse the courtroom meetings, the courtrooms itself were on the 14th, 15th, 16th, 18th, 19th, etc. Nowhere close to the ground floor and the plaza and the sidewalks. So, but that being said, the court still maintained that the judiciary still had the ability to restrict access to not just the courtrooms on the floor of where they're located, but the entirety of the floor itself. So not just the courtrooms themselves. They just struck down this particular rule because it included areas of the building that could not be considered to disrupt courtroom proceedings if you're using an audio recording device.
So I don't think these are any of the cases that you mentioned at the end of that during our conversation. Like, I have notes on a couple of them. Like, I think you had
the one I distinctly recall was U.S. versus Hastings.
Downer v. State. What was this most recent one you're mentioning? Because like I'm just trying to like absorb the story.
The one I just talked about was Dorfman versus Meisner.
And what year is that?
That was June 19th, 1970, and that was a Seventh Circuit. Oh, oops. Now, like I said, the only case I recall that I mentioned to you was the United States versus Hastings. But you also said Downer versus State.
Yeah, Downer versus State, Adderley v. Florida, U.S. v. Coquinda.
Ah, there it is.
Yeah, I mean, as far as courthouses and courtrooms, you know, I think that a lot of the precedent you're going to have to cite is like decades and decades old, and that as time has gone on, like those have even gotten tighter. Like I was talking with someone in the chat, you know, the comments section. I know it's a terrible idea, but like, you know, I did it anyway. And they mentioned basically like a rules of procedure, like I guess just like a bench order or bench ruling from, you know, one of the, you know, whatever the top judge was in Cook County, and that you know, basically you couldn't record anywhere in any of the buildings. Like I think that you had to like turn off your cell phone at all times. Like, I don't think you had to surrender it, but I think that like the ruling was like you had to just turn it off, like it couldn't be on, like you'd be in big trouble. And that was like all of the buildings, but that was like years and years ago. And if you go and look at how that stands now, it's like one courthouse in the entire county still has that. So it's, as time has gone on, like even that's kind of slowly gotten whittled away. Like judges themselves are kind of walking back on those decisions. And I think that there's a reason for that. You know, the people who work in courthouses aren't beyond reproach, and the public has a right to be able to inspect that. And if you look at the Hastings decision, you know, that is you know, that's one of the prongs that you have to pass. There, you know, the government's interest in keeping that information, you know, restricted has to outweigh the public's interest in knowing what the heck is going on. And you know, that's, so there are other cases that you can point to. I think that I don't know if you mentioned this one, Cuba versus 1A Agricultural Association.
No.
Ninth Circuit. Time, place, and manner restrictions can't be too strict. The language is, provided the restrictions are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant governmental interest, and that they leave ample alternative channels for communication of the information. I think that like they were some sort of animal activists, and they wanted to record like something that was going on there, like they wanted to shoot the rodeo or whatever. You know, they basically, because of I think it was either I I think it was that they needed to buy a ticket in order to be there. Otherwise,
Okay.
they were going to be ejected from the place, trespassed, and like they were basically allowed to, they were given some basically like a protest area that they were allowed to monitor what was happening in the loading and unloading of animals. I think for whatever was going on in the and so like that they ended up doing that and defending their rights. I believe that was that case.
Okay. I mean, the strongest case that I was able to find in favor of what a lot of these auditors do was out of Glick versus Cuniff, 655 F3D 78. It was a Ninth Circuit decision from 2011. And the issue involved the plaintiff was arrested for filming police officers, and
explain it. But this is my home state, so yeah.
But yeah, so and it was at the Boston Common, I believe it was. Oh, or maybe that's a different one.
Nope, you got the right one.
Okay. Wait, why is it a Ninth Circuit decision then? First Circuit. What? I don't know why I said Ninth Circuit. First Circuit. My bad. Okay, that makes sense.
I said Ninth Circuit, so yeah.
Okay, First Circuit. Yes. Yes, he was recording the police while on the Boston Common, and the officers arrested him for essentially filming. The court held that, based on where he was located, which was Boston Common, based on the fact that it was like a traditional public forum, so your First Amendment rights are the strongest when it's on a traditional public forum, and the clear interest in monitoring the conduct of police was paramount, and therefore the court held that his First Amendment rights were violated, and that you do have in the First Circuit a First Amendment right to record public officials. Now, what's significant about this is that the court explicitly said public officials, including police. So it's not just simply police officers who may be subject to recording. And what I've seen from other cases in other circuits is that's distinguished in some areas. Some areas will also include public officials. Others talk about police, specifically police officers, and recording what police officers do in the course of their duties. I will say, though, in most of these circuit level decisions where these the First Amendment is involved when it comes to video recording public officials, it's unless I missed one, most of them all involve police conduct. The facts of the case are involving police conduct. It's usually not your county clerk. It's not your it's not the court clerk at the lobby of the courthouse. It's usually involving police, and usually involving police while they are out in public in a traditional public forum. And going into that, when you had just mentioned dealing with time, place, and manner restrictions, the court in the First Circuit in Glick said that the right to film is not without limitations. It is also subject to reasonable time, place, and manner restrictions. But they didn't go further into that because they felt like they didn't need to, because the facts were blatantly obvious that the plaintiff's First Amendment rights were well within the bounds of the Constitution's protections in the based on the facts on hand. So, as you mentioned, this First Amendment right to record is subject to time, place, and manner restrictions, right?
Right, and I have no disagreement with you on any of that. For instance, I mentioned the example. You can't, even though you can, you can't trespass the eye, right? Like that's one that you'll hear all the time. That's like one of those mantras that you hear auditors say, and like it's just sloganeering, right? Like because you can't, like, if I'm standing outside of a bathroom and I'm filming, I'm just standing my monopod there at the door, hoping to like catch glimpses as people go in and out. Like I'm gonna either get my ass beat, and like probably justifiably so, or get trespassed, or something. I think that any reasonable person would see that situation and say that there's something wrong with that. I think that any judge would see that situation and say there's something wrong with that. Like there should be statutes that stop that activity. I think that that is a reasonable restriction on your right to record. People have an expectation of privacy when they're going to take a dump.
Well, I mean, we're not in any disagreement there, but you make, but you
can see that you can trespass the eye in that circumstance, and any normal person is going to agree to that, because who wants to be photographed taking a dump? Like that's, there you go.
But you make
out from there if you're ever talking to one of these people, for instance. But yeah,
right.
I think that if you expand that, and I see auditors who go through these buildings and they'll sometimes film into offices that are people's workspaces, and that's not all right. You need to point your camera at the floor when you're going by that door, because that is where they have an expectation of privacy. That is not where the public is let through, unless it's a situation where, like, I know that there are offices that have services that they offer where you can go into an appointment with someone, and they'll have a meeting in their office with a client, and that would be a space that maybe you could make an argument that because the public does go through there, if you caught that, like, but that's a very, I don't know, I think that's kind of a dicey proposition, and I think that people do have an expectation to privacy, unless the person who is in that office basically invites you in, and that you should not film that.
Well,
I think that the guideline that the federal law very explicitly lays out, if it's a hallway, if it's a foyer, if it's a lobby, it's an entrance, if it's an auditorium that people are having a meeting in, you have a right to record there. In Massachusetts, I hate to keep going back to my state, but I think that there is a, along with those, the courthouse procedures that state that, in general, unless there's a particular reason to restrict the access of the public to record in the courtroom, they say that it's, unless something, there's a security reason or something, unless like, unless there's a judge's order or something particularly restricting it, you can't ban the public from recording public meetings that are happening in any courtroom. So any, like, city council meetings or board meetings or things like that, the public does have a blanket right to record effectively. And I think that that's a procedure as well. It's like, it's basically your local C-SPAN, but like, so no one's going to watch it, but at least it's out there if they do.
Right. Well, I don't disagree in that regard, at least when it comes to public meetings. And I think actually that's already been, that actually has been decided in a circuit. It hasn't been decided by SCOTUS, but it's already been acknowledged that at a public meeting in certain circuits that you do have the right to record an open meeting, like a city council meeting. Executive session meetings, no, but open meetings, yes. So, and I'm not in any disagreement with that, but the focus of our discussion was dealing with whether or not the courtroom restrictions can go beyond the courtroom and into the courthouse, and then from there we can move to other public places, because I think based on what the law that I've seen, the case law that I've presented, I think that the courts do have, the judiciaries of the states do have the authority to restrict audio and video recording even outside the courtroom. They also have the levity to, promote it, because, for example, in my state, New Jersey, you cannot audio record at all in the building. You can use your cell phone. You can have a cell phone. You can use your cell phone in the lobby of a courthouse, and in certain open areas of the courthouse, you can use your cell phone, but you cannot use it to record. You can record outside the building on courtroom grounds, but that's the only allowance for being able to audio and video record. Any other, if you want to be able to record while inside the courthouse, you need permission, prior authorization from the court. So and that's how it is in New Jersey. I know other states have theirs different. I know, as you mentioned, Massachusetts has theirs different. So with that said, I think it's
Can I respond to that?
go ahead.
I think that, I don't know if it probably wouldn't apply, but I think that the spirit, one of the things that you mentioned about the Glick case, is that um, it was also used to overturn the state's wiretapping statutes that were like, that was what was originally invoked to try and to invoke the arrest and start the entire procedure.
Mm-hmm.
And I think that on those same grounds that like orders like that probably wouldn't be upheld as lawful, because I don't think that you have, there's a blanket concern that the government has with keeping those areas private. I mean, if I think that just as, I mean, why would that be private? People walk through there all the time. I could just hear what you said and write it down, really. Um, it's kind of it's a strange restriction. It's a strange restriction to, have the public not be able to video record in places where there are already video cameras being set up.
Well, those video cameras are there for security purposes. The video cameras that are there are not there to record what people are necessarily what they're saying. I don't even know if many of those cameras can even pick up audio in the first place. But
yeah,
if
that's the ruling from the judge, like, yeah, I mean, I understand
the
that would be upheld, but I don't think that that's right.
The other point is that those security that security camera footage isn't going to be uploaded to YouTube. I mean, that's the concern here, is that if that footage were to come out and be publicized, there can be ramifications for somebody disseminating that information. Whereas if some random Joe or random Tom, Dick, and Harry decides to go out with a recording and just so happen to pick up some sensitive information that they were wielding, and then they upload it to YouTube, there's not going to be much of a consequence in there because of the anonymity that is YouTube. And so that's the issue that people have, is that there is very little control over how somebody's going to use the audio, use the video, and disseminate it, especially when it comes to these auditors who claim to be members of the media, yet do not adhere to the sort of ethical privacy, standards that most traditional media abide by, which is, don't put my face on camera, don't record my please monitor what I record so that sensitive information doesn't inadvertently get broadcasted to the general public. That's the concern.
I agree with you there. I disagree that in general auditors don't do that. Maybe it's just that I swim in different, I see that, I bump into you occasionally in the comment section in some auditors channels, but maybe you kind of see a worse sample than I do. That the way algorithms do, if you look for ones to like be critical of and I look for ones that don't annoy me, that wouldn't surprise me. I don't watch the auditors and I don't like give views and algorithm heat to like any auditor that I don't like. And I'm sure there are plenty, but I think that you're a little, I don't think you're accurate about most broadcast companies not broadcasting your face. Like I can't imagine like the local news just like blurring out every face that they see. Maybe they won't be focused in on those people. And I don't think that auditors should be, necessarily focusing in on someone. A lot of the times what you will see is that an auditor will just be, have a camera staring off at the middle distance or like pointing at a door, like they're gathering B-roll for like, what you would see on the nightly news. And, someone will say, "Are you recording me?" And just shuffle right up to the camera and stick their face right in front of the lens and start screaming, "You're recording me." I don't know whether like, they're idiots or they deliberately want to become some sort of viral video. But I think that that's a situation that they have every right to broadcast. I think that on legal grounds, if you say that it's incorrect to broadcast things to the public because there might be that information there, I think that the case law says that you actually need to have the cause for your recording in situations. Your First Amendment right only is extended if you intend to broadcast things as news. You can't just like go and say, oh, I'm going to be recording this for my personal video collection. That's not a First Amendment protected activity. You need to actually have the intent to be broadcasting some segment of that as news. I agree that a broadcaster has a responsibility, and I'm sure a court would agree that a broadcaster has some responsibility if they did something criminal, as far as standing in the wrong place or broadcasting sensitive information. But outside of outside of that level of irresponsibility or culpability or negligence, or however you want to frame that, whatever the case is, I think that you do have a right to record, you do have a right to broadcast it, and I think that this is an anonymity is actually an advantage in encouraging that among people who are speaking truth to power and trying to communicate misdeeds of local police, of local judges, of local politicians and officials.
But at the same time, I also pointed out that in many of the instances where you talk about the news gathering situation, I'm not denying, and I don't think anybody is denying, that courtroom proceedings are newsworthy. They're inherently newsworthy, but they're also the court has, or Supreme Court has already said that the First Amendment does. And as U.S. versus Hastings point out, that the access to the courtroom proceedings by being physically there and observing satisfies the First Amendment. You don't need to extending that to audio and video recording is not there. That's not part of the protections. So.
No,
I know that's what these current auditors hate, because if I'm going to pretend and entertain them by saying that they're journalists, I don't think they are by the traditional definitions of the term. But notwithstanding, let's pretend that they are. They whine about that idea because they only operate on video. They don't write anything. They don't do anything other than video for their journalism. And the problem is that most traditional media have abilities beyond being able to use their cameras. So if they're going to act like journalists, they need to expand their abilities beyond the video camera if they want to actually do their job. So that's why I have very little patience for that. And going back to the old idea with the courthouse, the reason why I go with the courthouse is because in a courthouse, there's a lot of PII there. There's a lot of personally identifying information at the courthouse, number one, because you're dealing with people going to court for civil issues, criminal issues, family issues, landlord estates, etc. And you're going to have social security numbers, bank accounts, credit card numbers, and full names, DOBs being expressed, written down, talked about, handed over all over the courtroom, even outside of the courthouse. And it's going to be very hard for people to be able to talk to each other and have a conversation with each other if you're seeing somebody wielding a camera to and fro. And the concern is, I don't know who this person is. I don't know who they work for. I don't know where to go if by some horrifying situation that my information is somehow spread because of this person. Because again, an auditor has almost no ethical compunction about prohibiting personal PII from getting out on their YouTube channel. Very rarely have I seen that. So the courtroom, the judge and the judiciary is going to say, you know what, because of that, yes, theoretically you can also overhear it and you can like write it down, but it's a lot harder to disseminate that information when you don't have a camera. And I think that's the point that a lot of people are trying to make when it comes to these restrictions.
Well, in response to that, I would just point to what's going on in the Michigan courts these days. You know, they have all of their proceedings that are going out on, you know, they're being conducted on Zoom that are going out on YouTube. So, you know, I agree with what you're saying, but on the other hand, if they're able to conduct that business while still satisfactorily protecting people's personal information that way, you know, if they can do it, it can be done. You know, I can't disagree with you that there are people who do the job badly, but doing the job badly doesn't mean you don't have a right not to do the job. You know, that's like a subjective measure. You know, just because someone sucks at being a journalist and being an ethical journalist, that doesn't mean that, you know, it suddenly becomes a crime to be a shitty journalist.
No, but that's also a factor. That's also a factor in the time, place, and manner test.
Huh?
That's a factor in the time, place, and manner test, right? If there is a significant government interest in protecting the PII of the citizenry, that's a factor when determining a time, place, and manner in allowing audio and video recording, is it not?
It might be, but again, you know, then why is that not being tested? You know, why isn't it passing that test for Michigan? Why is Michigan able to like get around that? One of the other tests is that it has to be, you know, kind of the only remedy that's available. If there's another remedy that's available to the, you know, to the people that are doing the proceedings, such as, you know, keeping that redacted, only having that information, you know, maybe not reading that information into the record in cases where it is known that someone is going to be recording, having that information just like entered digitally into the record, that things change.
Right, but we're talking about the floor, though.
I'm sorry?
We're talking about the floor. There's nothing against states being able to liberalize their courtrooms.
People recording in like the lobbies or like the hallway outside the courtroom?
No. I'm not talking about a literal floor. I'm talking about the floor in terms of what is or is not, what can or can the court not do in terms of restricting audio and video recording. We're talking about a floor, and what I mean by the floor.
I thought we had established, you know, the floor is where it was before any of those proceedings came down, right? You know, like the Lindbergh baby, where everybody was walking in with video with you know, flash bulbs,
right?
You know, just basically bedlam. Yeah, so like that's the floor. I mean, where it's moved to now, I guess that would be the floor. I guess you're saying like, where should we set the floor to? I don't know. Like I really don't know.
I'm not saying
as far as like the courtroom, as far as the courthouse, I think that there should be very few restrictions. I think it's kind of nonsensical, you know, to say, well, somebody might see a piece of paper that's sticking out of somebody's like briefcase, or, you know, someone's got a manila folder and they're not holding it closely enough. Like who, like, you know, so buy an attaché case. Like,
well, that's fine. Well, I guess here's the thing. I'm not here about what I think the law should be, or what I think should be. Sure, I personally, what should or should not be allowed. My whole bit is whether or not the court has the authority to restrict audio and video recording in a courthouse, not just the courtroom.
I guess it would depend on the jurisdiction, because I don't think that the Supreme Court has made such a ruling on video recording.
I believe, as far as the courthouse is concerned, I do believe that it's only been determined at the circuit level. And now when we go there, and so I think that at the courtroom level, it's absolutely been decided by the Supreme Court. So the courthouse, but at the courthouse level, I believe it's still a matter of the circuit courts but the circuit courts have favored restrictions on the courthouse, well, of those circuits that have addressed the issue. Now, when it comes to our other discussion, when it comes to non-courthouses, right? There is a level of variance among the circuits. Like I said, Glick in the First Circuit, in my opinion, has the most liberalized opinion, meaning not just police but also public officials may be able to be recorded. they haven't really discussed any specific instances in terms of like a county that I've seen that involve like a county clerk's office. You know, what some of those we typically see in a lot of these auditor videos where they go to a county clerk's office and go to a clerk front window.
I really no. I don't think Glick applies. I mean, maybe in a certain sense, but Glick happened in the middle of the Boston Common,
Right.
Common courtroom.
But that's segueing into my next part of the discussion, and part of the test that's used in determining whether or not there are greater allowance for a government to have restrictions on the conduct that goes on in their building is based upon whether or not that building or that space is considered a traditional public forum or a public forum. And in the Glick case, the Ninth Circuit said Boston Common, by its very historical tradition, has always been a matter of free speech. It's so.
If this is not a public forum, then there are no public forums.
Exactly. I mean, exactly. Pretty much what the court said. Now, I've already seen in many of the cases that I cited to you, in one of them I think was Downer versus State, and then the other one, those were to demonstrate that courthouses are non-public forums, or they're limited public forums. So as a result of that, there are greater. The government has greater authority on the conduct there. One of the cases that I read dealt with like a bunch of religious individuals who were soliciting, in a courthouse lobby. Like they're not allowed to do that. So even though that would be a restriction on their First Amendment rights of religious expression and I think assembly, the court was like, no, the lobby of a courthouse is not a traditional public forum. In contrast, they would say, as I mentioned earlier, a city council meeting is a public forum, because oftentimes you have people who are able to express their decisions, express their grievances at the end of a council meeting. So there's less restrictions that are allowed in that context. But in many of these instances, such as like city halls, courthouses, those are considered to be limited public forums, and they're not traditionally meant to be places where people are just randomly go in and express their First Amendment. They're intended to be places where people are there to do business. And if you're not there to do business, what else are you going to be there for?
Your business could be recording the courthouse. I mean, your business could just be, I'm a citizen journalist. I'm standing around. I'm waiting to, go record something in a courtroom. I really don't, think that you need business beyond being a journalist, standing there recording something that's of public interest. I think that you're in a lot of cases. As far as back up a second, as far as recording in the courtroom, what I think, to answer your previous question, what the floor should be, all in one. What I mentioned earlier, what I think Massachusetts, just their rules of the court are, that it is up to the judge's discretion, but a little asterisk next to that, the judge has got to have a pretty good reason why he's not going to let that happen. If it's something like, there's going to be a lot of private information that necessarily needs to be discussed and needs to be read in the court record. But if it's something that's just, an arraignments for what's, for the people in the drunk tank, that's pretty straight up. You can just stand there and record that. That's not a big deal. And that usually is a public interest. For instance, I think is something that we could probably both agree is something that there's not really a high degree of privacy that's expected or necessary in that circumstance, in that particular courtroom.
Okay, I mean, you can have that as your argument if you're going to argue your case.
Well, I'm talking to you and trying to see where you stand.
My stance is simply a matter of the courts have the discretion. whether I disagree with it or not is a separate issue. But my base is based on the precedent and based on the case law that I've seen. The judiciary has a fairly wide latitude on the conduct of their courthouses and courtrooms.
What about cases where the courtroom is already being recorded?
Okay.
Should that, does that, give an implied right to record to anybody that's in the courtroom? Would you agree with that?
No, because most of the time the issue would be a matter of the record itself.
I mean, it would have to be as like the rules of the court, but like I don't know. I think that like a lot of these restrictions that would be placed, like you're going to see them phased out because they don't pass that test that was set out in Hastings.
I mean, okay. I mean, do you have any cases where that's been overturned based on Hastings?
Test. So like there you go. I mean, I mentioned a couple already.
Which one?
Cuviello versus City of Oakland, Ninth Circuit. Public venues must allow space for First Amendment rights to be expressed.
Was that a courthouse? I thought that was the cattle thing or the animal rights activists.
That was Cuba versus First 1A Agriculture Association.
But do you have one involving a courthouse?
Yeah, Hastings. Like you have the test, and like these all are invoked. These all like have basically invoked that and invoke each other, and like they're kind of consistent. I mean, I know that you want to just kind of have me present my argument and just say and like have that kind of be the weight, but
you were the one who called me out on it, so
well, yeah. So I think you still have yet to make your case. Like
I thought I did make my case.
Yeah, I think I did too. All of Michigan is broadcasting their shit. Now what?
I already told you that how Michigan has the discretion.
Court at this point,
Michigan,
like that's still the case.
I'm not saying that there's no restriction, that there's no courts have that aren't allowing more access to the courtrooms in terms of recording. That's not the issue. The issue is whether or not they still have retained the authority to restrict recording in the first place, and they still do.
Under those conditions. And one of those conditions, as Cuviello and Cuba both say, is that there has to be at least some path given, and that the people that are imposing the restrictions like have to make sure that that's the only remedy that's available to them. But if, for instance, you could set up the rules of the procedures of the court so that you had a greater degree of scrutiny about the information that you're using in order to try a case, you might therefore be able to allow a broader, carte blanche, if you will, for allowing people into the courtroom. If sunshine laws are passed, then all of that gets thrown out the window. All of those rulings get tossed out the window.
Well, I mean, that's awesome for the hypothetical, but I'm still relying on what it is the here and now. And I've already stated that, yes, that Hastings...
You're literally saying it depends, and I'm saying, okay, well, let's be a little bit more specific.
No, I'm saying it fairly definitive right now that unless you can find me a direct challenge on in terms of the courthouses, the judiciaries of the respective states and the feds have the authority to say no cameras and no video allowed without express permission from the court.
Within a courtroom, yes.
I'm also saying it within a courthouse.
And I'm saying that, like, you look at all of the different that are being handed down by, the higher courts that are in Massachusetts, what the rules and the procedures are, what you're actually allowed to restrict, and under what grounds you're allowed to restrict. A judge basically has to make a case for why that exists. That goes back to Hastings. We had both agreed on this. I don't know why you're trying to like do this weird flex, but like,
what do you mean flex?
Where you're just like come up with a case all of a sudden. It's just
I am coming up with a case because I thought we already agreed that Hastings was specifically about courtrooms.
Right. And what we're agreeing with is where those courtrooms and where those judges' rules basically have to lie. And like we were talking about the particulars, and I thought that that was interesting, but I guess we kind of exhausted this. So I don't know.
Okay, my understanding.
I have my opinion.
I think I think we're mixing up court cases though, but maybe we're not. My understanding is like I mentioned Hastings and you scoffed at that because that was specifically geared towards courtrooms. I then went back, did more digging, and did a bit more research, and I found cases that supported the authority of the courts to restrict audio and video recording to the entirety of a courthouse, not just the courtrooms.
Yeah,
that's
in the 70s,
and I know you keep saying back in the 70s, back in the old times, in the long ago, but there's still good law.
I've mentioned more recent cases and circumstances where that's all been rolled back.
Which ones in terms of the courtrooms?
And we've both agreed that there's not a Supreme Court case to like hang our hat on and say, oh, it's been decided.
I'm well aware.
2 Ninth Circuit Court cases, so like
no, I told you that the First Circuit Court cases of Glick had nothing to do with the courthouse, though.
Like I've got video. I'd like, we can do reactions to things. We can talk about places beyond the courthouse. Like I don't know where we're gonna go. Like Cuvelo, Cuba, look them up, read them out. I don't know what else to say. Like the courthouse is has less restriction than a courtroom. It is it's almost certain.
You haven't really just demonstrated that, though. I've already given.
I can go in there to conduct business in it. Like those rules of, you can go in and basically do anything on, I believe, poster 7 in a federal courthouse. I don't know, like if a state courthouse can suddenly say, oh, well, anything that goes in federal court, we're going to go all the way up to the federal courts and say that the procedures that are followed in federal courts shouldn't apply in a state court. I'm sure that's a great argument to put before a federal judge. But no, I think that that's all pretty clearly laid out. And if you'd like to move on, we can. I think that we're literally beating a dead horse at this point. But
I'm not sure, because I don't think you've really demonstrated that courthouses are less restrictive than courtrooms. Beyond the fact that the SCOTUS hasn't definitively stated so.
You have business. You literally said before that you have business in a courthouse, that you could go. You have to go file things. You might want to look up the record for a case that previously existed. You might need to, any of a number of things. Seek out, a legal aid. Public legal aid that might be, available only in the courthouse. They might have offices there. There's lots of reasons why you might want to go. Like,
okay, I'm not saying that there's no reasons for not going to the courthouse. But right. even if you have business there, if you have business there, you still can't record without permission of the court, depending on what jurisdiction you're in.
Right? Yeah, sure. Poster 7, yes. Those are the federal like poster 7 comes from federal procedures that like are written elsewhere than just the post office.
Okay, like, I know.
Right. Yes. So like, I thought I had just laid that out. Like, but
the judiciary is still
are going to go to like, the Supreme Court and say, well, our rules need to be followed, even though these federal rules are, are set as such.
But that deals with government buildings, right? Which includes, but the judiciary still has control of the conduct of the courtrooms.
If they can defend that, like, if you want to, and if the judge wants to file a contempt charge against somebody because they broke their ruling, then you just show cause and you fight it all the way, and you just defend your First Amendment rights.
Right.
Yeah. Tally ho.
Okay.
Like, yeah. It's just that nobody's done that as far as the Supreme Court yet. So, like,
right. So okay. So all right, we're in agreement now that the courts have that restriction, and it's just a matter of time before somebody challenges it.
I don't know what you. Okay, I guess so. Like, I'm not sure what you like. What exactly we're agreeing on, because it sounds like we were disagreeing. But
well, I thought we were in agreement.
The courthouse, like. I'm saying that if a judge wants to, a judge can find somebody in contempt for anything. Like, he doesn't like your haircut, finds you in contempt. But like, then yeah, you challenge that. A judge has broad latitude in that. Artie, I mean, would you disagree that if a judge just doesn't like what you say in his courtroom, he can find you in contempt? Does that mean that it's legal?
Okay. We're
like, that's basically what your argument boils down to.
No, that's not what my argument boils down to. I thought that was your argument.
No, that's literally your argument.
I thought that was your argument.
Okay.
I feel like
okay, argument,
dude. What's your argument?
My argument is that there is a public interest, and it's been recognized at the federal level that the public has an interest in recording in certain times and places, and that judges basically have, some reign in where they can allow and where they disallow. A lot of jurisdictions have broadened up their restrictions. For instance, Michigan is broadcasting pretty much all of their courtroom proceedings. They'll mute out certain information. They'll make sure that it's not available to the public. But I think that that's, an indication of where the courts are going. And that's an indication of like where they probably should be at now. It's just that there's a lot of jurisdictions that are kind of sticking to archaic laws. Yeah, I mean, there's a lot of laws that people that lay out that that aren't right, that aren't constitutional, frankly. You have people who get pulled over for having obscene bumper stickers. Like, that's not legal. that won't work, but they can still get arrested. They should still yield to the arrest, and then they should fight it in a court. But that doesn't mean that it's legal, and it doesn't mean that it's right. I mean, it's legal with air quotes around it, but like, legal writ large, if you take that all the way to the mat, it's not.
And okay. All right. And what I am saying, and here's my argument, just so that we're both clear on our positions, that based on the case law that I've cited, the case law that I've found, that the authority of the judiciary of both the federal and state court systems is great enough to restrict the usage of audio and video recording devices in a courthouse, not just a courtroom. You
can't find a ruling that says that it survived a challenge to a courthouse.
I literally have been citing that to you the whole time.
No, you're citing a courtroom.
No.
Yes.
Okay. All right. So okay, let me give you the case. All right. Dorfman versus Meisner. 7th Circuit. They struck down the rule at the time, but they upheld the ability of the court to restrict it.
Nothing's coming up.
Huh?
I keep putting in Dorfman v. Meisner, and nothing's coming up.
430F.2D558.
The link in the right?
Yeah. Well. I don't know where I could find it in public access. Hold on. Here we go. All right, I put in here's a link to it. And then Mazzetti versus United States was a 10th Circuit decision that also said that, the court can restrict audio and video recording within the courtrooms as well as its quote-unquote environs, which included areas outside of the courtroom. Mazzetti versus United States is 518 F2D 781.
So they say, we hold that the district court may, by rule, exclude photographing and broadcasting from those areas of the courthouse which would lead to disruption or distraction of judicial proceedings, but that the rule complained of here goes beyond the scope permitted by the First Amendment. Accordingly, plaintiffs were entitled to a declaratory judgment of that effect, an injunction prohibiting enforcement of those parts of the rule declared invalid. So, like, that doesn't seem like they're saying that it's, you know, the strictures placed were could survive a First Amendment challenge.
I had already explained this earlier in our discussion. I thought you were listening to me. I gave you this entire case, and I told you explicitly that the court had struck down the rule, but they had stated earlier that the judiciary could restrict access to recording devices and audio devices of the entire floor where the courtrooms were located, not just the courtrooms themselves. It's just that in that particular rule, they included the plaza and the open lobby of the building on the ground floor, whereas the first floor that contained the courtrooms was on the 14th floor. That's where they say that there was the restriction was too broad.
Right. And again, this is a place, you know, this is a decision made in 1970. And I'm not saying that because it's like, oh, that's past the expiration date. I'm saying that the equipment's old. Like, you're going to see it, like the opinion. So as far as legal philosophy, like, do you consider yourself a positivist? Or like what sort of, like, I'm not sure, like if you're talking about like rulings, you know, what do you see as how, you know, what is jurisprudence? You know, how does stare decisis work over time? You know, are you an originalist? Do you believe in positivism? You know, obviously not natural law, because that's what crazy people think. But yeah, you know, it goes down to, I think, what you see as relevant in you know, looking at these rulings over time. And I think that there's an element to like the strictures that are placed in decisions that go back over time on the fact that like photography equipment used to be really fucking big. And it used to take a lot of lights, a lot harsher lights, less natural lights than are able to be used by cameras now. And I think they were much more obtrusive. And I think that you know, courts at all levels were making decisions that were observant of that. And I think that, you know, I think that that's allowed, you know, that it would be allowed on those floors, but I don't know if that would still survive, you know, because of what they said, that it has to, you know, it has to be a concern to the disruption or distraction of the judicial proceedings that were being undertaken. Right.
But can you concede that I've given you the case law that you were looking for, that they can restrict beyond the courtroom?
I will concede that I was not able to absorb all of the details that as I was listening to your narrative. I'm tremendously sorry that I did, you know, but I didn't get a chance to read this beforehand. You know, no discovery, man. I prepared on things that you had already cited. If you wanted to give, like, I was here 20 minutes ahead of time. Why didn't you give me the links to like these cases if you're going to be citing them?
Well, because I thought you were going to give me your counter cases. I thought you had cases that you were ready to counter me with, and we were going to have a discussion on them. But if you're just going in and saying,
well, I mean, you didn't mention any of. I didn't know that like I was going to be quizzed on case law. Like I looked up the cases that you had mentioned at the last meeting, but you know, forgive me for not absorbing what you were saying through YouTube.
But you were again. You in the live stream, you were calling me out as if you knew case law to the contrary.
Like who listened and who didn't listen. But like we can both agree at this point that like yes, you can. You know, there are restrictions that can be placed. Those restrictions have been, you know, kind of whittled away over time, and that. As far as what I mentioned before, you know, the federal rules of where you can be in a public building and start recording, you know, the entrances, foyers, yada, 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 auditoriums that are being used, hallways, and lobbies. Yeah, like that's kind of included. And, you know, with respect to this decision, it's consistent.
Okay.
Yeah, so I think we are kind of on the same page. I think that
we are now.
Well, Oh, come on now. Stop. But yeah, I think that I think that we both see gray, but I think that it might even be like you would say it's half empty, and I would say that it's half full. I think that it's a way that it's being framed, and I think that honestly, to say that a lot of these broad restrictions, such as the case of that woman where she was walking around in the courthouse, the instant case, if you will, I don't think that she really did anything wrong. She's an obnoxious person, but the places that she was recording, I don't think that was really a big problem. I didn't see if she flashed the camera into people's offices, which, as I mentioned at the top, that ain't cool.
Well, she did. She did. To just real briefly, she did right before she went into that records room where all the hoopla began. There was a room that was closed off, and she decided to put her camera right in front of the little slit where the room was closed to see what people were doing, and those were clearly workers' offices offices in there. So she was doing that. That was right before the records room.
And if she did record that, she should have blurred it, or she should have edited it out with like a lapse and just moved forward. She should not have broadcast it. That I don't agree with. That is irresponsible, and it was wrong to record it. She could have been trespassed at that point because she's very evidently breaking people's right to privacy. There's multiple witnesses that are seeing that, if that's the case, and that I think that she has broken the rules. She's broken the statutes and the laws, and get her out of there.
So we are. I mean, again, if we're a discussion of what should or shouldn't be allowed is ultimately academic. Again, but if we go in,
it's very
right.
subjective.
I mean, it's subject to. I mean, that's why we have cases and court hearings, because the facts of the case can turn on whether or not there is a rights violation or constitutional issues raised.
Yeah, absolutely. I think that if she had, how about this? If she had not, barring, recording people's offices, are there any other places that you think that she shouldn't have been recording? Was the records room a problem?
I would have said the records room was definitely the problem. Even if all she did, okay, let me go ahead and make a personal opinion. If all she literally did at the time was just wander around the halls and not actually go into some of those buildings, such as there were closed off areas that had, for example, the coroner's office. I don't think, filming corpses is a First Amendment protected activity. I kind of hope that you would agree with that, and I'm glad. Thank you.
No, and I think that people have a way, just so long as people have some other way of knowing like who died in town, as far as, the public records are concerned, they can file a FOIA request. If we lived in some dystopia where that wasn't possible, and somehow the First Amendment still survived, then yeah, I guess you could do that. I would say that might suddenly become necessary in some bizarro world. But yeah, it stands now, that is
setting aside, yeah. but again, setting aside, there are cordoned off areas, certain areas of the building. If all she was really doing was just in the hallways proper, right, I wouldn't have had much of a stink about it before. But she went into the records room, and the records room is exactly the place where I would have issue, because you're now in the area where there's people's case files. And many of those case files will have that PII there. And that's why the guy, the first thing he says, like, you cannot record in here. And I think he didn't necessarily, I don't think he necessarily meant the entirety of the courthouse. He meant in the records room. And I think that's a very specific place where you should not be allowed to record there. Because even at the open area, even if I don't know if you saw in the video, right before she walked in, it said that records room is available for public viewing, so you can go in there to view. And I know in New Jersey, part of the records law, you can go there and you can view records. You can actually take notes. You cannot record there. That's the one restriction. But you have that other means of access, right? Which is also part of the test. So that's where I had the issue of her going in there, and that's what created the stink, because she was in a room that was very specific in terms of you should not be allowed to record there because of the risks involved.
I agree with your analysis. I disagree about the recording. I personally feel that you're right. That is not ethical to record people in there. I think that that might be a problem if you're, you know, focusing in on individuals, you know, trying to snoop over their shoulder and record information. But legally, I think that she did have a right to record in there and like what she was doing, given that there was no one else was in there except like the grumpy dude and the photocopier that was in the corner.
There was 3 of people in there, I think, at the time.
Was there?
There's at least 2 because there was that.
Then the video sufficiently focused on them that I didn't really notice anybody else. Like, you know, maybe they were in the distance, but like I wasn't even aware that they were there. You know, so the video mostly focused on the grumpy dude, and if they, you know, they were just recorded just in the distance. You're not trying to get their information. The video camera is not of sufficient quality to be able to get any personal information broadcast. I don't think that's a problem. I think people have a right to use their camera phones in there, definitely, because they shouldn't have to use that photocopier if they want to get information. They shouldn't have to take notes. Like somebody might have a disability where they might be precluded from taking longhand notes about very important things about court cases that they might very much have to win. So I think that they should, you know, not have to pay money for a photocopier. They should not have to take manual notes if they have a disability. You know, for that reason, it should be legal for people to just take out a case file, any case file you're legally allowed to access, and just put your camera over it and take a photograph of it. If you can get it, you should be able to take a photograph of it. If you can take a photocopy of it, you should be able to take a photograph of it. There's no reason not to.
Okay. I mean, that's your opinion, man.
I mean, do you disagree on the legal posture there?
Yeah. I think because, again, the risk is great enough that you're going to take pictures of more than just what you're looking for. And there's going to be instances where there's going to be more than one person who's going to be looking at files.
Well, I mean, like if you're going to photocopy a thing, like how is the risk any greater if you're going to take a photograph? You just take it out to like one of the little cubby areas
because you're making the photocopy. You're
photograph it. You put it back.
No, you're making the photo. People need the photocopy for their own filings most of the time, and even then, again, it's not just you looking at your own stuff. It's the risk that you are going to pick up more than just your own information.
So I'm talking about like being able to just use your camera to take a photograph of something you would be legally allowed to take a photocopy of. Like I'm assuming that you can access those records so that you can take a copy of those records and use those records in you know, a subsequent case.
It's dependent upon what records you're looking at. Right. Some records you may only be allowed to view. Again, it depends on the state. You may only be allowed to view. You cannot make photocopies of them.
Right. I'm assuming, like, I'm saying I don't know, like, what the statutes were in the place where she was. Like, I really, you know, I'm sorry I was unprepared.
It was Illinois. I don't know about Illinois' public records law either.
Like, she could just, you know, assuming it's not like, you know, some particularly restricted file, she should be able to, like, you know, if you can photocopy it legally, you should be able to photograph it. I think that's, you know, that is the law. I think, you know, at least where I am, you can take your camera out, you can take photographs of records that you're able to access and photocopy and, you know, just read as the public. Yes, like that, those are all things that should be legal. If they're not legal, I don't think that those laws should stand because the public has an interest in being able to do that.
Well, like I said, I mean, the access is still allowed there, even if you don't have the ability to audio and video record. And I think it's there to balance the potential privacy implications that can come with taking out your camera and photographing in the middle of a records room. So I understand where they're coming from when it comes to restrictions in that regard. And I guess we can agree to disagree, and we can move on. Or
you're saying this, but I think that, you know, the rule is that you kind of have to create your own privacy in that circumstance. Like I hate the, you know, the sloganeering about it, but yeah, you kind of do. If so, you know, I think that what that woman was doing in that scenario, I'm saying that I don't think that legally she did anything wrong. She shouldn't have been kicked out. Like, she's annoying. I hate her. Like, that's, you know, I agree. All that, you know, fine, but I don't think she did anything wrong by like busting out a camera and recording a dude who's specifically telling you can't fucking record in here, because like I think she could. I think that was wrong. And I don't think she was, I didn't notice that she was recording anybody's personal information. I agree with you. I now that you mentioned it, I believe that she, I do recall that she briefly did exactly what you said as far as going into, I don't remember that she like walked into an office area. But
she didn't walk into it. She was just outside the door.
I do remember seeing that and when I rewatched it. So that was just my faulty memory. My bad. But yeah, that's not allowed. That should have gotten her trespass. But I don't think what she did in that room, as far as just recording the dude and like the room, that's not really a problem. Like, she had a right to stand there. Like, as a matter of procedure, you really shouldn't be recording in there. You can ask her to stop. I don't really think you can trespass her. Like, just make people aware of what's going on. If people want to like stop looking at records until she leaves,
So the other people have to be inconvenienced by her waving her camera around.
I don't know. Like, I'm pretty sure if it's disrupting the operations of the court, we already did that.
Well, I mean, if somebody was already there looking at a personal records or some sort of records that they would prefer somebody not see that they're looking at them, or they're meant for them themselves. Now you're saying that in order to create their own privacy, they have to hold their arms up like this to avoid her camera?
I mean, there should be areas that, are sequestered and screened off that, like, just somebody can't casually look over my shoulder with or without a camera. Like,
but sometimes there's not enough space in a courtroom to be allowed to do that.
Like, I'm sorry?
Not all courtrooms are going to have that sort of space to allow privacy areas.
Oh, come on. Yeah, not all.
Really?
Of them, but, like, pretty much, yeah.
You think a small town's records room is going to have enough space for somebody to have a complete enclosure away from any potential prying eyes?
Like a little study cubicle where if it would be conspicuous if somebody was like suddenly looking over your shoulder, where you do have a little bit of privacy. Yes, of course.
But even then, according to you,
down in my little hometown district court, yes, there, down in the basement next to the records room, it's a little area, little cubbies, you can go and sit.
But even then, assuming that there are cubby holes over there, what's to stop her from looking over her shoulder and seeing what you're looking at?
Then you would say, you don't have a right to do this, and you would go to order, and then she would get.
I have to create the privacy, right?
Then have grounds to kick her out.
Right. Okay. So I don't need like a poncho. So I don't need a poncho, right, in order to completely enclose the cubby hole, right? At least you can concede that. To avoid any potential of recording of somebody.
Take a breath, dude. Let's say she doesn't have a camera. Let's say she's just like looking over your shoulder. What do you do?
Tell her to stop.
Yeah,
and get somebody out there to tell her like this woman's invading my privacy.
Exactly. Right. That's already a thing. That's a thing that we already do. Without the camera, it's a thing. Right. So there you go. If you're videotaping, if you're photographing, if you're making someone uncomfortable, if you're disrupting the proceedings of the court, what we were talking about just before in Dorfman versus Meisner with way too many letters, then you may be booted the fuck out.
So but again, just on that situation, the ability for recording, because cameras can have certain zoom levels, they don't have to be right over your shoulder either. But even then, that's the whole point.
I don't think she had line of sight on anything that anybody was doing. I didn't see her recording anything. She was looking at the dude 99% of the time.
The point is,
doing something with the and if you have a telephoto lens, like, it's not inconspicuous.
The point,
no way. And if you have a telephoto lens, you basically need the power of a star in order to see something that far away. So yeah, I'm going to call BS on that. Well, that's not an easy trick to pull off. I don't know much about photography.
The point is, rather than having to deal with situations like that, the court saying no cameras and videos allowed, period, and allowing people to have the appropriate levity to do what they need to do, look at what they need to look at without the fear of somebody recording what they're looking at from a distance or from close up.
I Yeah, they should. And I don't think that someone is going to be able to record you at a distance without you, without someone being aware of it to some degree. I mean, it's not an inconspicuous activity that you can do. If you're whipping out your little camera phone and you're recording the dude who's there, you've got your GoPro with the giant wide angle concave lens that like sees everything, vaguely, but nothing in particular. You're definitely not going to be recording somebody's personal information at a distance. Like there are cameras that are specifically made to do that sort of activity that you can guarantee that you're not going to be recording information. And honestly, even if you were there and you're disrupting somebody who's doing it, if someone just feels uncomfortable and they ask, the person, the grumpy man by the copier to ask you to leave, he has a right to ask you to leave at that point. But what if you're somebody who goes in there and the grumpy man doesn't want to give you records because grumpy man is also racist? Hypothetically, I don't know that he is. I'm sure he's a lovely person, but what if he is? Or do you have a right to take out your camera then? He's a public official. So we just looked at the Glick case where you can overturn certain strictures and laws. Massachusetts has one of the toughest wiretapping laws in the nation. And it did not apply in the Glick case because there was a public interest in recording what was happening with this police officer. If this guy is working for in a government position, he's collecting a government salary, being a grumpy man next to a copy machine, and he's being an asshole and violating your civil rights. Do you then have an interest to record that would override, the court order?
I would imagine that you could put that there, and even if, and then you could have an interest if the worker is being a prick. You may still be trespassed, but then you have a video that will showcase why you were not adhering to the rules of the courtroom. Because hey, this guy is as a government official is preventing me from being able to access records based on the color of my skin. I mean, so yeah, of course, I'm not going to say anything about they shouldn't have recorded in the first place. But I think that that's the point, is that the general rule is not to allow video recording, to safeguard the interests of the court and safeguard the interests, the privacy interests of the individuals that are going there for court business.
All right. Yeah. I mean, I agree with you there. I think that in those circumstances, if you did start recording the racist guy, he would call to have you trespassed. You would be trespassed unless, someone had gone through there with an monopod and been an annoying Karen and, actually gone through those circumstances and, quote unquote, educated people on the First Amendment rights that they have. You might not be trespassed in those circumstances if there's been some prior exposure to those, the way that works out under law, on the part of the people who work there or the police or both. But yeah, I agree that that's the way that it should work, and that you almost certainly will be trespassed. And if you're trespassed, don't fight the police.
Right. So I think there are. I mean, I know you've already mentioned that there are legitimate interests in the reasons why a court or judiciary would want to restrict the uses of cameras inside of a courtroom, largely on the point of what can go on. I mean, I know you're saying that certain the First Amendment interests of being able to record public officials in their capacity may override them, but it's not as if the sole purpose of these restrictions is to hide the shady shit that can go on in a courtroom. There are certain factors that are going on there.
There are legitimate reasons to do that. I think that unfortunately, an externality or a knock-on effect, if you will, to those legitimate reasons is that sometimes it does hide a lot of shady shit.
Okay, but also that there are other means of being able to engage and have access to court business that are available even if the restrictions are there. And that's one of the
transcripts available. There are often audio recordings that are made by the court, specifically, like for instance, in traffic court
in New Jersey. Here, they have that all the time.
Yeah, and you can just go and request them, and they'll make a copy. You pay them money, and they send it to you, and there you go. And that's all great and good. And I think that's that does satisfy the requirements of the Constitution. If everything's going well, I think that there is a reason. Assuming that things are on the up and up and things are honest. But like, how can you really ensure that unless there's some objective reference point that is outside of the purview of the court, i.e. citizen journalists, commercial journalists, proper mainstream journalists, or whether they're actually employed by a journal of record or a broadcaster or whatever, or they're freelancers that are working on a story or might try and sell that story, sell swords.
Well, again, I mean, the court did talk about that. I mean, again, within the context of courtroom proceedings, but
Yes.
Bear with me. They did talk about that in the sense of, the First Amendment's right of access to the courtroom was that physical presence and observation. And the court said that the rights of the media are no greater than that of the public. And in Glick, they point out that because the individual whose camera was taken was not a member of the traditional media, but it didn't matter whether or not they're traditional media or not. They still had that right of being able to record. So
yes, that's a very good point. Thank you for mentioning it.
Right. So that's the thing. I know a lot in my camp, like. And I agree. Like most of these authors, they're not fucking journalists because, in my opinion, journalists have at least some level of ethical standards, and these guys don't. They make themselves part of the story, which is not what you're supposed to be doing. But I digress. Regardless of whether they are or are not journalists, they are still subject to the same standards as traditional media. And in that regard, traditional media have restrictions of their own. And if the media have restrictions of their own, so too does the public, which I think is something that I feel like some auditors don't understand or don't want to understand or don't realize. So part and parcel of that is in the courtroom, in at least New Jersey, you can file a request to the court saying, I want to be allowed to record the proceedings. And so everybody who wants to record is still subject to that request. Whether that should be allowed, and instead it should be, people should be allowed to record unless the court gives a reason not to. I mean, that's an academic discussion we can have at a later date. But for now, the coin is currently set on the other side in terms of the court can have the ban unless a request is made and the court authorizes it. Whether it should be on the other side, we can have that discussion. I sometimes lean towards that, but that's what the current allowance is.
Yeah, I think that the court doesn't have a legal obligation to open things up, in any sense. I agree with you there. That is the law as it stands. I think that as time has gone on, and as time will continue to go on, you'll see that courts are going to probably have a looser hand on the reins. You might even see situations where courts or municipalities, counties might even offer some sort of identification or just education classes or something, just so that you can have citizen journalists that are able to record that, so that they are aware of the ethics and the laws that they have to abide by in order to accomplish that. There might be a list of friends of the court that are allowed to have proven themselves and be allowed to come in, and that might be a way that there's like a pseudo carte blanche for most proceedings in general, and there might be a very good reason for that might alleviate some of the pressures of the tests that are set out in Hastings, and allow the court to actually end up having broader constrictions, like you said, you can shut down the entire courthouse and not even let people turn on their cell phones if you have a handful of people that are known to the court and that have have taken the certification class, for instance. You have to have a license to drive a car, you have to have a license to own a handgun, you have to have a license to be able to come and film in a courtroom. got the manual. I've gone to take my road test. I know how to use the camera and not blow myself up. Let me go at him, coach. And like, yeah, that might be the future. But, you know, I think that as it stands right now, generally, like, yeah, it should basically fall along where the federal, you know, rules that we've talked about, the post office rules, Poster 7, whatever that federal law, you know, federal regulation is. Yeah, I think that that's fair. I think that that's probably where things should be set for courthouses.
Okay. I mean, and so, yeah. And again, like, I've seen district court cases, like, again, district level, so they're not necessarily precedent, but district court cases where they've upheld a blanket ban on cell phones, period, where, like, nobody could have access to cell phones unless you were a worker or an attorney. I mean, that's probably the strongest restriction I've seen. I know somebody mentioned that in their state that's a statewide thing where only and I believe actually in there as you mentioned, no, I'm sorry, it wasn't just attorneys, it was attorneys, employees, and members of the media, as you said, that were registered, that signed up and for an application as to register as a member of the media. And the court upheld that as a valid restriction. What's that?
Yeah, that's pretty cool that, you know, that they would have a list. Like there's a question of you know, how accountable is it if the court gets to say who holds them accountable. But I think that shows progress, that you would just have, you know, hey, sign up and prove that you're not a crazy person and come to court. I think that's awesome.
Let me see if I can find that case. I have my list here. Oh, that's right.
As I mentioned before, I someone who was a commentator or a commenter in your previous video with the lady who was going crazy in that courthouse. They mentioned that Cook County had a restriction on pretty much all but one or two of their courtrooms or courthouses, that you couldn't even have a phone on. You know, unless you were like an attorney and you needed it to like present something or read something or, you know, check your email or what, like, you know, you could get permission from a judge to turn it on, but you would need permission from a judge to turn it on. And it was accepted like one or two courthouses. And that was passed like that was a rule that was passed in like 2012 or 2015 or an order rather, I believe. And that, you know, you fast forward to 2020 and, you know, the case is reversed, that now it's only stands in one courthouse. And I don't know, you know, what that is. I really think that, you know, the major reason why that's not done is because they would have to rewrite a lot of procedures, because, you know, court procedures require that a lot of information literally just be read into the record because it's set up for audio recordings. And, you know, if you're doing that, you're falling in precisely the peril that you described before, that anybody who's, you know, just like live streaming that is going to put sensitive information out on the internet. And there are other ways to enter that private information into the record other than to, you know, read it out, and people can, you know, access it even if it's not on the audio tape that's being set up by the government. Usually that is, you know, the reason why that's a procedure in a lot of court, you know, in a lot of jurisdictions now, right? But you could just change that, and there would be cause to change that, and maybe good reason to change that. If, you know, wanted to allow citizen journalists in there to record, and, you know, they could just see everything else that's happening that wouldn't be in an audio recording, see everything that wouldn't be, you know, in the court reporter's transcript.
Well, that was other
that there's, you know, public interest in that, and there's a reason why you would want to do that. I have, you know, some examples of you know, if you might be interested in them, judges being naughty.
I mean, I already know of at least one case where a judge was not, he was not doing something good on the bench, but we're not going to get into that tonight. But yeah, I'm well aware of that.
Like 2 or 3 minutes, and they're kind of funny because like some of them are like, yeah, judges go off. They're people. They can do bad things, both, you know, from most of these, I believe all of these that I have are, you know, from the bench, bad things that they've been accused of and admonished for, or reprimanded, rather. But, you know, they do other things besides naughty things from the bench, and that can get kind of funny.
I think I think the issue would be that because yes, I understand that premise of being able to hold judges accountable for what they do. That's why the access is there for them. And especially in our current situation that we're dealing with a lot of these recordings being broadcasted on Zoom or other technology, it's even becoming even more transparent, and maybe that'll end up being and that is turning into the catalyst that may end up liberalizing a lot of the previously set rules. But I will say that as of right now, as we currently stand, the courts have that levity available to them.
So that's a link to there was a recording made by the court, so that's the only reason why we have it. But it's an example of some misbehavior from a judge in your home state. It's a few years ago, but the video is only about 1.5 minutes. But if you don't mind, I'd appreciate getting your reaction on this.
Okay.
I think like I've been saying, I think we've trod this ground long enough. So
right. This, I mean, I could take a look at this and we can discuss it, and this might be just what we can do to wrap up for the evening. It's getting.
I'd like to watch one other video that's about a guy from my state that does an audit, and it's of interest because I don't want to, I'll when we get there I'll show you, but I'll put that in the chat as well. It's a little bit longer. It's 10 minutes.
All right.
But I think it's interesting to get your reaction, your analysis on that too.
Okay.
Pieces of paper, his Social Security earning statements, which he doesn't have, and this supposed report that exists for Lehigh.
He gets his Social Security every year indicating
The earning statement.
He gets his earning statement.
Okay.
He gets it. He gets it every year.
All right, so the first one is
So she asked
just
for,
a
why
minute
didn't he
and a half,
provide
and
it?
it's
He
the
doesn't
raw
have it.
video from the judge. I also have another one that's a news story follow-up that gives a little bit more context and what ended up happening to the judge. But
oh, that's right. I feel like I need to share. That's right. Hold on. There it is. All right. Can you see it?
yeah.
All right.
There you go.
Then now Ms. Kolsky comes back after everything was finished except for those 2 pieces of paper, his Social Security earning statements, which he doesn't have, and this supposed report that exists for Lehigh.
He gets his Social Security every year indicating
The earning statement.
He gets his earning statement.
Okay.
He gets it. He gets it every year. So she asked for it. Why didn't he provide it?
He doesn't have it.
He doesn't. He threw it away?
I would presume he did.
Oh, come on.
If you say he got it, Judge, I don't know.
Don't you get it?
No, I don't get it.
You don't
get it, Judge.
I get it.
I don't get it.
You get it? You get it? Everybody gets it.
Everybody gets it.
I must be the one that doesn't get it.
Social Security sends it to your home
They do.
every year.
They sent it to my home 4 years ago. I haven't received it in the last 3.
Well, when did you become an illegal alien?
Judge,
Oof.
It comes to you.
Judge, I am going to. That was a totally inappropriate comment.
I didn't mean it. I'm only.
Oof.
Listen to me.
Okay. So the judge is an asshole.
Yeah, I actually don't have a video news story follow-up. The third link that I gave is to www.law.com. I'll actually paste this in the chat too, if anybody wants to just read it. You don't have to go over it, but yep, yeah. So there's the link if anybody wants to read it. But yeah, that just a little context. That lady was I believe the president of the Hispanic Attorneys Association of New Jersey. So or I don't know if that's the exact name, but more, that thing, the thing that, you know, she's the president of this association
Right.
for all of these lawyers of certain ethnicity, and you're calling her an illegal alien. And like, yeah, you know, there's another judge that's mentioned there, but you know, you'll pick up on which one is
right. I knew. Yeah, I figured she was from the Hispanic Bar Association, but I do point that the audio, the transcript video, right?
Yes, and that's great, and I think that more courts should do that. If they did that, then you wouldn't need to have anyone doing that. The point is that if you have recordings of judges doing naughty things, then you can catch judges doing naughty things. There is an interest to having recordings like this. Imagine if you didn't have that video. Imagine, you know, if you had to go to court and you have to like have people reenact by reading off of transcripts. Like, there's just so much more of an impact to the wrongness of what happened in that courtroom because there's an actual live recording with video and audio of what happened there. That I think that, you know, as much justice as this judge was made to see, you might not even get that if you don't have that visceral impact when you're trying to, you know, present the wrongdoing of this, you know, of this judge. There's a lot in the judge's corner, and it's you know, anybody that is in that situation, I'm sure that attorney appreciated having the video recording.
Right, I'm sure she did, but that also it did come from, you know, the official sources from the court and not from somebody else recording video. But I just wanted to make that point known that
I will do not contest that, but not every jurisdiction is doing that. If more, you know, I've got no problem with Michigan broadcasting all of their proceedings. You know, I'm saying that this is the way that the courtrooms have been going. I think this is where the future is. I think that it's kind of foolish and against the public interest to resist this. You know, I think that you need to, you know, just kind of step up, change your procedures, and make sure that these resources are made available to the public.
I agree, and if you want these procedures to change, you do that rather than instead acting in defiance of the current rule and recording and then getting surprised that you're getting a contempt charge as a result.
Right. No, but that lady wasn't like recording in a courtroom. Like that dude, you know, the P. Barnes kid, like who tried to like rush past with his camera on. Yeah, stop him. Because like that's in defiance of the law. Like if the, you know, I think that the judge should have the right to restrict whatever goes on. I think it makes sense to kind of, you know, as you mentioned before, the way you described it before, have the coin be on the other side. That, you know, it has to be a circumstance where the judge should write an order that this is restricted, or have, you know, a venue where like certain courtrooms are going to, you know, just be automatically restricted. And if you know that it's going to be a sensitive information, you just send it to that judge or that courtroom, or, you know, that whatever, and make sure that it's going into this place where there is a blanket stricture. But I think that on the whole, courts should be allowed to, you know, people should be allowed to record in court, or there should be, you know, as there was in this case, a recording of, you know, the video that's made of two cameras, I believe, one on the judge and one on the, you know, on the court, and you can see everything. That was great. And I wish that would be the options that are available, because I don't think that, you know, just having a court reporter is cutting the mustard as far as what we can do to, you know, make the best presentation of information available to the public.
All right, what's this this last one's in Boston?
Yes, this is a post office, and this is the resistance.
Oh, this guy. I think I know who this is. That's right. He
downtown Boston
was recording at a shelter and got kicked out, or was asked to move on.
Yeah, I agree that you don't have a right to record at a shelter, unless, you know, again, you see someone that's doing something unscrupulous, then like you probably should start recording.
And well, I think the ultimate point is like if your entire thing is about, I think what really set people off about that is that if your entire premise behind doing this is against certain public officials or like the police, where those are the guys who put your hands on you, so you want to hold them to accountable. Sure, yeah, most people can get behind that. Most people won't get behind recording regular citizens who are in a state of vulnerability seeking access to services. Like,
No.
what are you advocating there, right? You're going after the wrong people in that regard.
It's not your residence, but like by whatever measure that somebody has a right to privacy in their bed, you shouldn't fucking record them. You should be stopped. That should be against the law. Your First Amendment doesn't apply there, and turn off your fucking camera and be a decent human being.
But I think that last bit is, I think, the ultimate point. Like even assuming arguendo that I was on a public sidewalk, so I can do, I'm free to record whatever. That's where a lot of us get this idea that a lot of these auditors have no ethical scruples whatsoever, because theoretically, he may have that right because he's on a public sidewalk to record who is and isn't entering into that shelter, but it's still a really shitty and scummy thing to do. And it's something that most people who are watching this would be like, why is he recording people in certain citizens in this state when I thought he was supposed to be doing, going after, crooked cops or corrupt politicians? Why is he going after citizens who are seeking help? And seeking services? I think that's where people have that issue.
Well, so here's the thing. Yeah, I think that he does legally have a right to do that because he is on a sidewalk and he is just recording people that are on the sidewalk. Just as long as he doesn't like follow one person around like that, that's starting to cross a line. But if you're just standing in front of a door and you're recording a door and people go in and out of the door as you're recording the door, you have every right to do that. I agree with you that it's probably it's pretty questionable if you're recording people that are in a state of distress seeking help at a shelter. Yeah, that's not all right. You do not have a right to go into that shelter and record either, unless that, as we keep on saying, unless somebody's doing something bad, then you probably should. And you're right, suddenly that right suddenly appears out of nowhere. It becomes manifest. But yeah, go on. I think these are pretty divisive. These post office recordings.
Go to the Article 7.
This video just got demonetized by the video insurance.
No photo allowed here.
No photos allowed here?
No photo allowed.
That's not true.
No photo allowed here.
That's not true, ma'am. That's not true.
No photo allowed here. What happened?
That's not true.
What happened? What are you doing?
I'm recording
Reporting for what?
because I want to.
No photo allowed here. Call the police now. No photo
Okay.
allowed here.
Call the police.
You need to put your mask down and put down the camera.
Yeah,
okay?
yeah. The
We don't know what
camera
you're
can see
doing.
you.
We're
What
gonna
you
call the
doing? What do
police.
you want
I'm not here for any ill intent, and I'm not here to cause any problems.
Right. So this is from February of last year.
Yeah.
So that they're
Are
things
you
haven't
spraying
gotten
on me,
better.
ma'am?
That's why they're asking him to pull his mask down rather than
You
keep it
spraying
on.
Lysol on me?
He's confused. The post office workers were not yet used to everybody dressing like they were about to rob a train.
Mm-hmm.
Everybody leave the window.
So I mean, this you kind of get the gist. They actually just kind of back up pick up stakes and leave. He gets a little bit of static from people, but if you want to check the timeline and skip around to when the police officers show up,
Ladies and gentlemen, there's an Article 7
before
right
then,
here on the wall
before
right
then,
here. You guys could
like around the midpoint, like he goes out and he meets a cop on the street, and that's
Mhm.
a message. And then a postal cop shows up.
I think these guys will get the message. I was just around the corner. Hey, you know, have your name and badge, please?
What's going on?
May I have your name and badge?
Yeah, sure. Here you go.
Is that what you say to the judge?
What's
Yeah,
that?
sure. Here you go.
Yeah.
That's what you tell the judge when you give.
Yeah.
Wow. I'm just here for service, and they abandoned the post.
Okay.
So we have an officer who refuses to identify himself. I asked
Could
him
you
to
pause a
identify
second?
himself. He said,
Mm-hmm.
Right. So he's particularly upset that this dude didn't identify himself because in Massachusetts, every municipality, county, state, they provide all their police officers with a badge. It gives their number. They also give them a photo ID with all their personal information, and you're required to identify yourself to anybody who asks you for that information when you begin interacting with them. That they have to. That's every police precinct. That's a policy there. It's written in the laws and the general laws. And here in Massachusetts, this is not a Massachusetts cop.
Right.
That's a federal police officer, and
Right.
that is why he's basically just kind of like, yeah, fuck off. I'm not identifying you. I'm answering questions.
Well-
Question answered.
Well, I mean, he was basically like, "Hey, you got the camera. It's right there for you
Yeah,
to see."
yeah, exactly. Yeah, exactly. But that's kind of the answer you'll usually get. But that's why he's, that's why he seems confused, I think, and why he's, takes a particular umbrage to that not happening. In case that wasn't clear to anybody.
But they can't fill anything that's postal, money, transfer money, or anything like that, okay? So they're allowed to film, so it's fine. If he wants to film, it's fine. All right? He can film, yeah, he can film. As long as he's not impeding the business, that's fine. Okay?
Thank you for educating him, officer.
Sure, no problem.
Would you like to reveal your name and badge, please?
Hey, it's right there.
Would you like to enunciate it? I can't read.
enunciate?
I can't read. I can't read.
You can't?
No, I can't.
Oh, okay. Do you have any creds on you?
Excuse me?
Do you have any creds?
Why are you asking?
To show you that you're media?
You're familiar with the First Amendment?
I am. Do you have any creds on you?
Okay. So if you're familiar with the First Amendment, then
Hold
you
on,
know.
let me answer this. This is for what, all right?
Am I detained?
No.
Okay. Well, I'm not giving you any information.
Okay, that's fine. Okay. You can stay in here as long as you don't
Impede anybody's traffic. I know I don't.
postal business and stuff like that, okay? So if you want to film, it's fine, but like I said,
Well, at this
no
point,
impeding the-
at this point, I have no problems with recording. I understand. I know my rights. I just need you to enunciate your name and badge number.
Real 7137.
Thank you, officer.
Sure. It's not officer, it's sergeant.
Thank you, Sergeant.
Right.
Yeah, and that's really the pertinent part.
Okay. So basically, the postal officer saying that he can record as long as he's not impeding the business or disrupting the business.
Yeah, more or
Okay.
less. You will often see people, and I'm not doing this to win any debate with you.
No, I understand.
This is something, but I feel like this isn't even a debate. We're just having a discussion.
Right.
I'm learning things. You gave me some cases to look up. And just, for the benefit of the audience, people that are, looking through this, I see people say, oh, all these people are frauditors. They don't have any right to do this. These people are all terrible. I think this is an example of a good interaction and a very clear signal from, a police officer that's obviously educated on the federal laws, and, he's there to enforce them. He deals a lot with the post office. So, if someone's going to know, that dude's going to know. So I think that's pretty conclusive to people who might be in your audience and think, this is not illegal activity. They go around, they see auditors getting kicked out and trespassed. I just saw in the chat earlier, just now, someone said, oh, well, he's annoying people. He should be trespassed and removed. And I said, just watch. That's not what's going to happen. Obviously, I didn't refer this because, I want to make myself look foolish. I want my dude's going to win. And I think that's a pretty decisive, that's a pretty decisive win. If you have a post office police officer come up, or police sergeant rather, come and tell you that, yeah, you have every right to record here. Tell the employees, yeah, he has every right to record here, and on and on. What you do see post office auditors do is they'll be like that little half door where there's an office back there and the operations of the post office. And again, you shouldn't point your camera back there, point it at the floor, or, don't focus in on it, flash past it. So it's really not, you're not able to see, the operations of the post office behind that magical door. There's an expectation of privacy.
Right, but I also want to point out that with the poster, the officer, and also with poster 7, is that your grant of being allowed to record can be taken away by that same officer.
It can, but so if the reason he's kicking you out is because you're recording, I don't think he can do that. I think you have, if you, obviously don't fight the man because he's got a gun and the ability to call infinite more officers on your ass. But yeah, you should, if that goes to court, I think you have grounds to say no, I was right to record there. He didn't have any right to trespass me. If it's just because I'm recording, that's a well-established constitutional right, yada, yada, yada. You might have grounds for a lawsuit on, 41 or 42, USC 1983 or whatever it is, like the grounds for civil action against something that violates your civil rights. And so, and on and on. But yeah, I think that, unless you're bothering somebody, unless you're disrupting, if you're stalking people, if you're, don't go into the post office without a mask. If there's a mask mandate, I see a lot of auditors do that. That's the most insane thing I can imagine. You have to have clean hands if you're an auditor. You are being held to a higher standard. You can't go in there and start fighting with people or cussing with people because you're causing a disruption, and you are cutting your own legs out from under you. You are whittling away your rights by bad behavior. And and at the very least, you want to look good in front of people. Yeah. I think it's 41 USC 1983. 1983, Scott.
Yeah.
Yeah. Oh Jesus, my cat just jumped out.
What just jumped out?
I think my cat just escaped out my back door.
Oh shit. You need to go get her?
I probably should go get him. There's coyotes in my neighborhood.
Oh God. Well, look, I mean, like I said, I was actually intending on kind of closing out with the videos that you showcased. So we could just conclude here.
I'm sorry for the rushed goodbyes. You've been lovely. I also wanted to say one last thing at the conclusion of this. All that malding talk, that's just banter, dude. I think you've got a lovely hairline. You're a handsome man. I didn't mean to disrespect you in any way. I think you're great. I'm a viewer. I'm a fan. I appreciate being invited on here to have this discussion with you. I'm gonna go get my cat.
All right, no problem. Go for it. I know what it's like.
Everybody in the audience. Goodbye.
Take care.
Thank you, God. Thank you.
Bye-bye.
Bye.
Well, hey, I cannot blame him if his cat suddenly got out, because I would probably lose my shit if Archer were to suddenly escape outside and I'd lose my goddamn mind. So I can't blame him for a short exit. I thought it was a good discussion that we had. I really don't think it was bad at all. I think that, we were able to at least find a little bit of common ground. But I think I did demonstrate to him what the courts can do. I know he wanted to kind of go into what the court should do or what the court shouldn't do in terms of restrictions, but I wanted to make it clear that this is what the courts can do. They can change, but sure. We weren't able to get into the Poster 7 and the non-courthouse government buildings. But it is what it is. But I appreciate that. It was a civil discussion. We had a little banter back and forth. That's fine. I mean, that's gonna happen. But I'm glad it didn't turn into a shouting match or a shit show. So I thought it was good. I was glad to see about having a civil discussion. Even if it's with somebody, just a random viewer. So thank you guys for dropping by and watching. Much appreciated. I'm sorry I wasn't able to pay attention to the chat. I wanted to try and focus my attention on the on the discussion itself. I know I missed a couple of super chats. Schrodinger with $5. Somebody told me about this Artie guy. I thought I should check it out. Catnat with $10. Great stream, Artie. Thank you very much, Cat. And Deacon with $10. You are not allowed to record in the building. She was recording in and she snuck into it. That's you can always ask for FOIA records. And if I see PPI, so could everybody else. So I understand. Yeah, that's what I try to ingrain into him, the idea of why there would be restrictions in a records room of all places, beyond just the courtrooms. I mean, that's where a lot of that PII is going to be located. And of course, they're going to have far greater restrictions on recording than in other areas of the courthouse, assuming that the entirety of the courthouse is subject to the same rules. So, yeah, I think we're able to get to that part of the issue that we were originally having the discussion about, which dealt with courtrooms. So, at least we were able to get through that. So, without belaboring it, thank you guys again. I'm gonna call it a day here. If this was a Friday, then I would do like an after show, after the show discussion, but I still have work in the morning. So I want to play some Fallout 4 before I have to go to bed. I've been addicted to Fallout 4 for like the last week and a half. Leave me alone. So yeah, I'm gonna have to stop it here. Tomorrow, I am going to have to. Tomorrow, I've already planned for it, and I'm going to be discussing the hearing of Light Tajiri Bay's counsel. I heard it. It is insane. It is anger-inducing, so I'm probably going to have the heart rate monitor on for that. So that's going to be tomorrow at 8 o'clock. Thank you guys again for watching. I will see you next time. Have a good night. Take care. Adios. Oop. Watch out. There we go.